Good afternoon, everyone. I'm Caitlin Hendrickson, Policy and Program Strategist at the Allegheny Conference. I'm glad that you could join us today for this members-only special topic briefing on vaccine mandates. Before we dive into our programming, I want to give a special thanks to our sponsors for their generous support that make this possible. Giant Eagle, PNC, Gateway Health Plan, Highmark, Blue Cross Blue Shield, Peoples, an essential utilities company, PPG, and UPMC Health Plan. I'd also like to thank the members of the Allegheny Conference's Regional Investors Council for their time, talent, and resources in support of the conference's work on behalf of the region, including and especially Jones Day Pittsburgh, with several of its partners featured as presenters here today. This special topic briefing comes at an opportune time. Across the country and across Southwestern Pennsylvania, more and more organizations, from businesses to schools to governments, are acquiring COVID-19 vaccines. These mandates affect employees, students, teachers, contractors, and others who regularly spend time in the physical spaces of these types of organizations. We're pleased to be able to offer this deeper dive into the legal and practical implications surrounding vaccine mandates. The conference has spent the last 20 or so months centering our work around the pandemic. Some of the immediate work included responding to help mitigate the health and economic crisis. And now on the other side of many of those unprecedented challenges, our focus is on a full recovery, making the region even stronger and achieving the vision of Pittsburgh as a region with opportunity for everyone. So there's a lot to be unpacked on this topic of vaccine mandates. So I'm going to turn the program over to Jim Urban, a partner at Jones Day Pittsburgh, to get things started.
And good afternoon, everyone. Thank you for joining today. We have a 1-hour presentation for you, and we hope to have some question and answer period at the end, so we can entertain any questions that might spring to mind as we roll through the presentation. I'm a labor and employment partner in the Pittsburgh office of Jones Day. With me today, I have two of my partners from our Washington, D.C. office. One is Andy Jackson. Andy is going to talk about an executive order that the Biden administration rolled out earlier this fall and where things stand and its potential implications. And then I also have with me today Brett Shoemate, and Brett is going to address issues related to the Occupational Safety and Health Administration's Emergency Temporary Standard, which impacts employers with at least 100 employees. Toward the end, I will talk about some general labor and employment issues that arise out of all of this. And so with that, can we bring our slides up? And I'm going to turn it over to Andy.
Good afternoon. On September 9, 2021, President Biden issued Executive Order 14042, which mandates that certain federal contracts and contract-like instruments contain a clause that require federal contractors and subcontractors to comply with guidance from the Safer Federal Workforce Task Force. We just refer to that as the task force. The president relied on a particular federal procurement statute that grants to the president and the executive branch the ability to issue rules and regulations regarding government contract. Presidents from both parties over the last probably 20 years have relied upon this statute to do things similar to what they've done here. As we'll talk in the litigation, folks who have complained about it are complaining the president overstepped his bounds. On September 24, the task force issued guidance that clarifies and expands on the EO, or the executive order. That guidance also includes frequently asked questions that answers a lot of questions that have come up. The task force uses those frequently asked questions to add additional detail or create additional obligations. At about the same time, both for the civilian agencies and the Department of Defense, FAR, Federal Acquisition Regulation 52.223-99 was issued, and that's the clause that is required to be included in all new contracts, contracts when options are exercised, et cetera. And that's the clause that specifies that contractors must comply with guidance, frequently asked questions, et cetera. The EO excludes certain items and certain contracts, including contracts with Indian tribes, subcontracts solely for the provision of products, employees who perform outside the US, or contracts or subcontracts whose value is equal to or less than the simplified acquisition threshold, which is $250,000. Again, the EO specifies that the language should be included in new contracts, new modifications, new options. Agencies were encouraged to try to convince contractors to agree to the clause earlier. Many agencies have already sent proposed modifications out to contractors, asking that the contractors agree to a mutual modification of existing contracts so that the obligation begins immediately. Contractors are not required to do that. It is a bilateral modification requirement, meaning both parties must agree. If companies decide not to agree yet to sign up to the mandate, then the government can look to the contract and see what capabilities it has, for example, to terminate the contract for convenience. But most agencies have said that they would not do that. Of course, all of this has changed a little bit because of the litigation that we'll talk to in a minute. The obligations on contractors and subcontractors are basically four. All covered contract employees were to be fully vaccinated for COVID-19 by December 8th, 2 days ago. That date was moved to mid-January. But again, because of some litigation, there's no real obligation right now. All individuals, including covered contractor employees and visitors at covered contractor workplaces, also had to comply with CDC guidance for masking and physical distancing. Covered contractors are required to designate a person to coordinate implementation in compliance with task force guidance and required safety protocols. And then finally, covered contractors must flow down the requirements of the EO task force guidance to lower tier subcontractors, except for subcontractors who are providing only products and that are less than the $250,000 simplified acquisition threshold. Subsequent frequently asked questions have expanded the definition of covered contractor employees and covered workplaces to reach folks not actually working on the contracts, but employees who are supporting government contracts, such as lawyers, accountants, executives within the company. And then a subsequent frequently asked questions expanded that to reach affiliates, that is, higher tier organizations within the corporate family. That was the rule that we were operating under until about 3 weeks ago, maybe 4. And there have been a multitude of challenges to the executive order. Right now, there have been 8 states who have filed lawsuits all around the country attacking the mandate. Those 8 lawsuits include 12 states, I'm sorry, a total of 28 states that have joined as co-plaintiffs in those lawsuits. There are also 6 private parties that have sued. All of the lawsuits seek to enjoin the government from enforcing the vaccine mandate and seek courts to rule finally that the mandate was issued contrary to law and that the president exceeded his authority. The Justice Department is defending the mandate aggressively in every one of these courts, and things are happening quickly. On November 30th, a federal court in Kentucky enjoined the government from enforcing the mandate in Kentucky, Ohio, and Tennessee. That court limited to those 3 states because the court believed it was required to define the limits of the injunction against the government more narrowly. On December 7, a federal court in Georgia enjoined the government from enforcing the mandate in all covered contracts in every state and territory in the United States. So right now, there is a nationwide injunction against the government from enforcing the mandate. Decisions in the other cases are pending, though it is possible that those courts might simply stay their decision-making process because a nationwide injunction has been granted. As recently as about an hour ago, one of these courts refused to stay its injunction, and the government immediately filed an appeal at the Court of Appeals. So we have the mandate at the federal appellate courts now in 2 separate circuit courts in the country. What are employer options right now under the government contractor mandate? Well, you don't have to comply. There is a nationwide injunction in place, and unless that is stayed or altered, contractors need not now comply. Many contractors, particularly those who have received these proposed modifications from their contracting agency customers, are going ahead and getting letters back to those agencies, telling them that they've received the proposed modification, they're evaluating the modification and evaluating what's going on in federal court, so that your customer agencies aren't simply sitting in the lurch waiting to hear from you. Other employers are also, while they've slowed the pace of compliance, they are still evaluating and planning on eventual compliance in case the mandate is upheld. As Jim will mention, the mandate permits certain employees to refuse to comply, and that if they receive and are given accommodations, and Jim will discuss the accommodation process. If the mandate is upheld, I think everyone can be comfortable that the government will be reasonable in setting times for compliance, extending out the times to comply. So I don't think there will be a situation where, if the mandate is upheld, that contractors have to comply the next day. The litigation, as I mentioned, is ongoing, it's active, and we're keeping an eye on it because things are changing every day. All right, I'll pass the baton to Brett, who will address the OSHA ETS.
Thanks, Andy. Good afternoon, everyone. Thanks for joining. I'm going to be speaking a few minutes about yet another vaccine mandate, this one from OSHA, the Occupational Safety and Health Administration, which is part of the Federal Department of Labor. I'm going to cover 3 points today. So first, I'll tell you a little bit about the OSHA ETS, Emergency Temporary Standard. Second, I'll talk a little bit about the litigation. And third, I'll talk a little bit about next steps and what to expect. But the bottom line to take away, like what Andy said, is that employers do not have to comply right now because of a federal court injunction. And I'll talk a little bit more about that in a few minutes. So first of all, what is the OSHA vaccine mandate? How is it different than what Andy was talking about? Well, if you remember back this past summer, President Biden ordered the Department of Labor, specifically OSHA, to issue an emergency vaccine requirement. And so it took OSHA, I think, about 2 months, and they finally issued what we call the vaccine or testing mandate in November, specifically November 5th. And the compliance deadlines, just to be aware of, they don't really apply anymore, but it was issued November 5th. The first compliance deadline was December 5th. And then the second compliance deadline that's upcoming is January 4th. That's when the mandate really kicks in. That's when the vaccine or test part of the mandate it kicks in. So what does this do? Well, this is a mandate for all the other employers, the private employers that are not covered by the executive order mandate that Andy just discussed. So if you're a private employer and you have more than 100 employees, this is the mandate for you. And it requires employers to impose a vaccine mandate on their employees. There are a number of exceptions for that, for particular employees, but also if you have employees who do not want to get vaccinated, there is a testing option. Employees can choose to get tested every week, which is another feature of the rule. So this was a mandate that was issued November 5th. It was immediately subject to a number of lawsuits, and I'm going to talk about that next. But first, what was at issue is OSHA's legal authority. And a number of plaintiffs are challenging the legal basis or statutory authority for OSHA to issue this emergency authority. I'll speak just a minute about what that authority is. So OSHA has a statute it implements called the OSHA Act, and OSHA issues a number of workplace safety standards that you're probably familiar with, but it also has a superpower called the emergency temporary standard power that it has rarely used over the last 40 or 50 years, but it allows OSHA to issue a safety rule that is immediately effective without going through any procedural requirements like notice and comment. So that's the authority that OSHA used, and to trigger that authority, OSHA has to demonstrate a grave danger and that the emergency rule is necessary to address that grave danger. So OSHA's rationale was COVID-19 is a grave danger to unvaccinated people, and they're imposing this vaccine or testing mandate as a necessary measure to combat the pandemic in the workplace. And so, as you can expect, that mandate, and you probably heard, has been subject to a lot of litigation, unlike the litigation that Andy described, which is currently playing out in federal district court for the executive order mandate for contractors. The OSHA mandate litigation is playing out a little bit differently. It's playing out in the federal courts of appeals because there's a special judicial review statute. So there are 12 circuits, and every circuit received a petition for review from a private employer or a state challenging the OSHA vaccine mandate. And so all of those cases have been now consolidated into a single court. So a single court will pass on the legality of the OSHA vaccine mandate. But before all of those cases were consolidated, one court, the Fifth Circuit Court of Appeals headquartered in New Orleans, Louisiana, issued a stay of the OSHA vaccine mandate. I think it was November 12th. So the order from the Fifth Circuit concluded that the plaintiffs were challenging the OSHA vaccine mandate had established a likelihood of success on the merits that the OSHA mandate exceeds their authority, and that businesses, employers, and individuals would be suffering irreparable harm if that mandate goes into effect. So the Fifth Circuit issued an order preventing OSHA from enforcing the mandate. The December 5th compliance deadline has already come and gone. And if this stay continues, that January 4th compliance deadline will come and go without OSHA being able to enforce it. And OSHA has indicated, they've made a couple of public statements saying that they are not taking any action to enforce the mandate at this time. They're not taking any steps to implement the mandate internally. So that's what happened in the Fifth Circuit. So that case and all the others are now pending in the Sixth Circuit Court of Appeals. That court, like the Fifth Circuit, is a very conservative court. It has a majority of Republican appointees who are likely as skeptical as the Fifth Circuit about OSHA's legal authority to impose this mandate. And we'll have to see how it plays out in the Fifth Circuit. So what's happening right now, in the Sixth Circuit, what's happening right now is that the government has moved in the Sixth Circuit to dissolve or lift the Fifth Circuit stay. It's kind of a very odd and unique procedural posture where you have one court, the Sixth Circuit, getting an opportunity to decide whether to lift another Court of Appeals stay pending appeal. So we're waiting for the Sixth Circuit to decide the stay. The petitioners have also asked the Sixth Circuit Court of Appeals to decide the case on the merits as an en banc court. So not just a 3-judge panel, but all, I think it was, about 16 active judges on the Sixth Circuit are being asked to consider the vaccine mandate altogether. So those motions are currently pending at the Sixth Circuit. The Sixth Circuit has not issued a briefing order on the merits. So we don't know when the Sixth Circuit will decide the merits of the case. But one thing to keep in mind is that the OSHA emergency standard is only good for 6 months and the clock is ticking. So it was issued November 5th. It expires 6 months from that date. If the stay remains in place for those 6 months, then the emergency standard has never gone into effect, will have never gone into effect. And then the point of an emergency standard is that it allows OSHA to draft a permanent standard. And so any litigation that's ongoing right now about the emergency standard wouldn't prevent OSHA from issuing a permanent standard at the end of these 6 months. But right now we're in the period where the emergency temporary standard would be effective, but for the stay. And so let's talk about next steps. What happens next? And what should we expect and when? Well, right now, we're currently waiting for the Sixth Circuit to do 2 things, maybe 3 things. The first and most important for your purposes is a ruling on the government's motion to lift the stay issued by the Fifth Circuit. So if the Sixth Circuit were to lift that stay, that means the OSHA emergency temporary standard would be immediately effective and those compliance deadlines would spring back into effect. But we'll talk a little bit more about compliance in a minute. We're also waiting on the Sixth Circuit to decide a briefing schedule for the merits. As I indicated, the Sixth Circuit is only deciding right now, has a motion to decide whether to keep the stay in place. The Sixth Circuit will also decide, based on full briefing and full argument, whether to uphold the legality of the OSHA vaccine mandate after full briefing. So we're also waiting for the Sixth Circuit to decide how they're going to decide these important motions. Are they going to do it as a 3-judge panel? Are they going to do it as an en banc court? This is important because it affects the timing, it affects the number of judges who are going to decide this, and it's going to decide who the judges are that are going to decide this very important question. So what we expect to happen in the next couple weeks is likely an order from the Sixth Circuit, either granting or denying the government's motion to dissolve the stay. And so what happens next? Well, the losing party will almost certainly go to the Supreme Court within probably 24 hours. They've got the papers already written, and they will ask the Supreme Court to either re-enter the stay, if it's the petition to the private parties, or if it's the government will be asking the Supreme Court to lift the Fifth Circuit stay and overturn the Sixth Circuit's decision not to lift the stay. And so that litigation at the Supreme Court could happen very quickly. Probably within a week, we would expect a decision from the Supreme Court on the stay. And so the next upcoming deadline is January 4th. I would expect we would get a decision from the Sixth Circuit on the stay, around, probably before Christmas. And then shortly after that, probably within 24 hours, losing party would go up to the Supreme Court and ask for a decision likely before January 5th or January 4th, when the compliance deadline for vaccines or testing comes into effect. But what does this mean for you? What happens if the Sixth Circuit or the Supreme Court lifts the stay and says the OSHA vaccine mandate can go into effect immediately? Well, like Andy said, our expectation is that OSHA will be reasonable and that they won't require employers to come into compliance immediately the next day. They would likely, although it's no guarantee, they would likely extend the compliance deadlines by the same amount of time that the stay has been in place. And so the stay has been in place for almost a month at this point. I think we can fairly expect that OSHA would extend any compliance deadlines by that same amount of time or perhaps longer, given the fact that the stay has been in place. Employers may not be ready to comply. So that is our current expectation, although no guarantee. And so one last thing is that there are also congressional efforts here in Washington to overturn the OSHA vaccine mandate. Our expectation is that they won't succeed. The Senate is currently, and both houses are considering what's called a Congressional Review Act resolution, which, if it passes by a simple majority, would overturn the OSHA vaccine mandate. It did pass the Senate, I think narrowly by 52 to 48 vote. Every expectation is that the House will not pass the resolution to disapprove of the OSHA vaccine mandate. And even if they did, President Biden would veto the bill. So the only chance to block the vaccine mandate really is through the courts. Courts have so far stayed any compliance deadline, and we expect a resolution from the Sixth Circuit on the stay this month and potentially from the Supreme Court before January 4th. So that's all I've got on the OSHA vaccine mandate. I am happy to answer any questions about the order, the litigation, and potential compliance. So thank you for your attention, and I'll turn it back over to Caitlin.
I'm sorry, I think I was muted there for a second. On my phone, actually not on the app. But anyway, so this is Jim. I'm going to just roll through some general labor and employment issues, and then we'll end with questions and answers that folks may have. The first thing I wanted to talk about was the issue of accommodation requests under Title VII and the ADA. This is coming up in the context of employers who are obligating individuals, their employees, to be vaccinated as a condition of employment, and threatening dismissal for failure to become vaccinated. So under Title VII, an employee can come forward with a firm religious belief that they contend prevents them from getting the vaccine. And then, of course, under the ADA, individuals can come forward and claim they have a medical condition or some condition that substantially limits a major life activity that also prevents them from being able to take the vaccination. When someone comes forward with an accommodation request, many employers are already fairly well down the road on this. You're obligated to engage in what's known as the interactive process with employees, and that is a dialogue that gets into specifically what the accommodation request is and what accommodation may be reasonable. A couple things are important to keep in mind is that you're not, as the employer, obligated to give the specific accommodation that is being requested. You're obligated to make a reasonable accommodation. So, for instance, a common accommodation request is that may I just continue to work from home or resume working from home instead of getting the vaccine. That will enable me to perform the essential functions of my job without raising the risk of infecting someone else in the workplace. So if that's the accommodation request, the analysis is pretty simple. Can the individual perform the essential functions of the job from home? And if you permit the employee to do so, does that create a substantial hardship for the employer? And in some circumstances, the answer may be yes. In other circumstances, the answer may be no. And so, an easy example is if you have an employee who must, as part of his or her job, go out to a customer site and perform services at the customer site. And of course, what many companies are doing with their vendors nowadays is obligating their vendors to represent that the individuals being sent on their property are fully vaccinated. So that puts the service provider in the predicament of I can only send on site someone who's fully vaccinated. I have this employee who is not fully vaccinated who's asking me if they can do their job from home. Well, if that person's job is to go on site to third-party customers, then the answer is probably going to be that's not a reasonable accommodation, especially if it's crucial for that individual to do that as part of the services that may be obligated to be provided under some contract with this customer. So it's an individualized process. On the religious side, it's important to note that under Title VII, the standard that applies to whether it's creates a hardship for the employer, the requested accommodation, is a de minimis standard, which is a little more different. ADA is more favorable to the employee. The employer will have to show a substantive hardship if that's going to be the basis for denying the accommodation request. There are going to be circumstances where, if the employee's been working from home for the past 15 months and has been productive in accomplishing what they're expected to accomplish and can continue to do so, even though you're bringing others back, there might be an obligation under the ADA, or likely will be an obligation under the ADA, to grant the accommodation of continued work from home or resumed work from home. The thing to be careful about in the religious accommodation context is really what the basis for the objection is. So the law is pretty clear that if the employee objects to vaccination based on social, political, personal preferences, or really any other non-religious concerns about the possible effects of the vaccine, that is not a firmly held religious belief that serves as a basis to request an accommodation under Title VII. So, the important thing is to go through the interactive process, document it, make sure you have the HR resources to handle the volume of requests that you expect to come in, and then just take them as they come and make the appropriate decision. Second bullet point here on the slide, can you incentivize employees to take the vaccine? And the answer is you probably can. So, the issues here are what you're offering and how you're offering it. So you can, a couple ways you can incentivize people. You can incentivize them to provide documentation of the fact that they're vaccinated. And then you can also incentivize them to participate in an employer-administered or sponsored vaccination program. So if you're talking about incentivizing them to provide documentation of vaccination, there's really no limitations that may apply. If you're talking about an incentive for them to actually get vaccinated, you need to be careful of it crossing the line and being deemed to be coercive. So the rationale here is that if there's, for instance, a significant incentive offered to individuals to become vaccinated, that they may feel pressured to disclose protected medical information as part of some pre-vaccination disability-related screening that can create issues for you. We have generally been advising employers that they should not be administering programs, but instead encourage employees to get the vaccine on their own and submit documentation of the fact that they are vaccinated to their employer. If you do choose to try to incentivize people, the ranges that we have seen are $200 to $300 ranges, maybe in the form of cash, gift cards, contributions to healthcare spending accounts. You can also have raffles for fairly significant prizes. Some employers are offering paid time off, although if the emergency temporary standard makes it through all the litigation, that there's an element of that requires PTO. So keep that in mind. Who pays for the testing of the unvaccinated if you end up going down that path and that you're actually providing testing to employers or to employees? You can have them do it on their dime, on their time. there's some issues I'll talk about in a minute related to that, or you can exercise control over the process and provide the opportunity for testing to employees. One of the, I think, bigger issues, especially in the Commonwealth of Pennsylvania, is that if you're obligating people to get tested on their time, there might be a wage and hour issue tied to that. The reason being that Pennsylvania's Minimum Wage Act is, at least for purposes of what is compensable time, is not interpreted consistently with the Federal Fair Labor Standards Act. There was a significant Pennsylvania Supreme Court decision from July of this year involving an Amazon warehouse where the Pennsylvania Supreme Court made two significant findings. One was, well, three actually. The first being that the PMWA is not interpreted consistently with the FLSA. And then as a subset of that, that the Portal to Portal Act, which is an element of the Fair Labor Standards Act, does not apply in Pennsylvania. And also the de minimis doctrine, which is recognized under the Fair Labor Standards Act, is not recognized under the Pennsylvania Minimum Wage Act. So for those of you that have operations in Pennsylvania, one of the things that you need to keep in mind is what obligations you may have under the Pennsylvania Minimum Wage Act that do not exist under federal wage and hour law. I want to skip to the last bullet point here to keep this moving along and talk about what might be in an employer's blind spot. The big issue I saw that really cropped up for me when the OSHA ETS popped up, and also when the executive order was rolled out, was the notion that we were going to have large swaths of individuals who potentially would be leaving the workforce, either voluntarily or involuntarily. So if you're giving folks a deadline to become vaccinated and then you're dismissing them for failing to do so, what that leads to is people talking to plaintiff side lawyers. And I'll tell you why that's important. Since 2005 or so, employers have been subjected to a wave of wage and hour collective action and class action litigation. So these are cases that are brought by groups of people, sometimes large groups of people with a single or one or more class reps. And they bring with them, because the class sizes can be large, significant liability. And any management side lawyer who's defended these cases will tell you how they typically get started is somebody loses their job, gets disciplined at work, feels they're being treated unfairly at work, and they go and speak to somebody who represents, plaintiffs in employment cases. And that conversation will go something like this: well, I don't think, madam or man, that you have any claims that you could assert related to your dismissal or the discipline or whatever the issue happens to be that brought the individual to the lawyer. But let me ask you some questions. Have you ever worked through your lunch break? Do you ever come in early? Do you ever stay late? How far away do you have to park? Do you have to ride a bus to get from where you park to where you actually perform your work? And it's those sorts of questions that lead to these wage and hour class actions that employers have to defend. So, my main thought when I realized that you may see large swaths of employees being involuntarily terminated from their jobs is employers need to make sure they have their compliance house in order, specifically under the Fair Labor Standards Act and wage and hour issues. Because the last thing you want is to be lawfully letting someone go because they failed to comply with your requirement that they become vaccinated. They go speak to a plaintiff side lawyer, and of course, it ends up 3 months later with a class action wage and hour lawsuit. I truly believe that there will be cases, a wave of cases of that nature that will arise out of COVID-related issues. People who went and visited with plaintiff side employment lawyers specifically to talk about their COVID circumstances and end up with wage and hour class action claims proceeding forward. So think about your compliance and your compliance house, and do you have it in order so that you're not going to have to deal with these issues 6 months from now, 9 months from now, a year from now. again, that bring with them significant liability. We're at about 12:40 or 2:40 right now, so why don't we throw it open for questions?
Thanks so much, Jim, Brent, and Andy, for all of that insight so far. So you've given us a lot to consider, so that's why we set aside some time for questions. So let's just jump right into the Q&A portion of the program, which will be moderated by my colleague, Rhonda Walters, Vice President of Talent Management at the conference. Rhonda?
Thank you, Caitlin. That was an outstanding presentation. A program like today's special topic briefing is one of the ways that the Allegheny Conference is providing value to its members. And I'm especially pleased to be a part of this one, since navigating the vaccine mandate landscape is a priority for me, and I'm certain for many others who are managing human resources. So I've learned a lot from our presenters, and I'm sure our participants have too. So I see we already have a question in the queue, and I know more will be coming. Just as a reminder, if you would like to submit a question for our presenters, please use the Q&A function in the Zoom, not the chat, but the Q&A function. We'll do our best to get as many questions in as we can. So let's get started. If you are under 100 employees, do you recommend not mandating the vaccine? And what would you do at this point as an owner? Panel?
I can jump in and start with that one, and then Brett or Andy can weigh in as may be appropriate or necessary. I think it really, the answer is it depends, and there's lots of things that you need to take into account. So, for instance, what industry are you in? What exactly are you providing, selling, creating? What is the nature of your work environment? Those are all considerations. If you have folks in close proximity to one another, and maybe they're going out to third parties and they're providing services, those are all the types of factors you have to take into account. One of the things that you can do is kind of work up to a vaccination mandate, and that starts with advocacy and education as to why it would be a good idea for your employees to consider vaccination. You can then, transition to incentives for them to become vaccinated, and then you can ultimately, if you think it's necessary, given what you do, the services you provide, whatever it is you might make and sell, to mandate vaccine. That can be kind of your final line in the sand. But it's not something that you necessarily have to implement immediately. It's something you can work up to. Brett or Andy, do you have any thoughts to share on that?
Jim, I thought your answer was spot on. I'll just say from a OSHA ETS perspective, look, if you have less than 100 employees, you're not legally required to comply with it. I assume you're not a federal contractor and don't have some other vaccine requirement that applies to your business. So you're not legally required to comply, but if you choose to impose a vaccine requirement on employees, that is within your discretion. Also, from what I've heard from my perspective, and others may have heard differently, the groups of employers that I've spoken with seem to fall into three camps. The first camp was kind of large employers who welcomed the OSHA vaccine requirement because they wanted to impose these requirements on their employees. And this provided kind of a political cover reason why employers could do this, and they could point to the mandate. Second group have been firmly opposed to it. Some have filed litigation. Others have, in the third camp that I've talked to, have been more in the wait and see approach. They haven't imposed any vaccine mandate on their employees yet. They're waiting to see what happens with the litigation. They're preparing to comply, but they haven't announced anything yet. So I would follow Jim's advice, but you don't have to impose the requirement because the ETS doesn't apply to employers with less than 100 employees.
Awesome. Thank you. Next question. Do you think the challenges to the OSHA vaccine or test ETS will be successful? And what are the chances that it will go into effect?
That's the million-dollar question. Well, we already know from the Fifth Circuit that a panel of 3 judges unanimously concluded that OSHA does not have the authority to issue the vaccine mandate. That's some good evidence. They have a very persuasive opinion. Now it's pending before the Sixth Circuit. The Sixth Circuit is probably the second best and second most conservative court after the Fifth Circuit to decide this question. So I think if I had to predict, the Sixth Circuit would probably agree with the Fifth Circuit that OSHA does not have the authority to issue the mandate. Now, when it comes to the Supreme Court, it really depends on the posture in which the case gets to the court and who's asking the court to take action. So, for example, if the Sixth Circuit keeps the stay in place, the government has to go to the Supreme Court and ask the Supreme Court to lift the stay. They have to get 5 votes to rule in their favor. Do they have 5 votes? I don't know. It's easy for the Supreme Court at that point just to simply deny. And then they can deny for any reason they want. They just don't think it's important enough. They don't think the government's facing irreparable harm. They don't think that the government wins on the merits. That's an easy way for the Supreme Court to just block it, is just leave the Sixth Circuit decision in place. Harder question, I think, is if the Sixth Circuit lifts the stay and the challengers go to the Supreme Court, can they get to 5 votes? I think we can count to at least 3 that would probably rule for the plaintiffs, the challengers. That would probably be Justices Thomas, Alito, and Gorsuch. I think we can probably count to 3 on the other side that would not rule in favor, would probably rule in favor of the government. I'd probably be Justices Breyer, Sotomayor, and Kagan. So that leaves the 3 justices in the middle, including Justices Kavanaugh and Barrett. Don't really know how they're going to come out. And then we've got the Chief Justice, who has been very deferential to the government during the pandemic to take emergency measures, with one exception. That's the eviction case from this past summer. So I hope it's not too much of a cop-out answer, but I think it depends on the posture that it gets to the court and how the Chief Justice feels that day. So.
Awesome, thank you. So we have one more question. We have less than 100 employees. However, 99% of our employees are vaccinated. Can we require our volunteers and interns to be vaccinated, even if we don't mandate our employees to be vaccinated?
I'll take that one. At least I'll start taking that one. So one of the things, lawyers are trained to do is spot the issues. And then once we spot the issue, we can go spend 6 hours in a law library and find out the answer. This kind of falls into that category for me. So the issues I see with this, well, there's a couple things. It's your property, and you can set rules as to who can come on your property. And so volunteers and interns, you would say, are not your employees. They're something else. They're invitees, I guess, from a premises liability standard. So you could impose obligations on them. The rub with that is that when you start exercising that sort of control over people who are volunteers or unpaid interns, you start making them you're exercising control over them. So you make them kind of look and smell like employees, which then could create liability issues for you under federal law, as well as the wage and hour laws, both federal and state. So if those are the issues I'd probably be researching if somebody came and presented a specific question. I don't know if Brett or Andy have anything to add on that. So I guess ultimately the answer would be it's maybe, but there's some issues you want to explore before you make a decision on whether you're going to impose this requirement on volunteers and interns.
Thank you. So let's see, we have another question here. Under the OSHA mandate, If it goes through, can you talk about the pros and cons of mandating the vaccine versus giving employees the option to get vaccinated, or allow testing without having an official mandate policy?
I can start on that one, and then I'll probably hand it off to Brett if that's all right. So one of the risks that you run by mandating the vaccine, and it's a practical risk, is you risk losing talent that you might deem to be key to your organization. People who you would not want to lose, you lose because you're mandating the vaccine and they don't have no intention of becoming vaccinated. Whereas if you proceed ahead with vaccine or testing as an alternative, you have a better chance to potentially keep those people employed and keep on board the talent that's important to your organization. Brett, did you have anything to add there, or Andy?
Yeah, the only thing I was going to add was, look, the OSHA vaccine mandate gives you the option. You can either require the vaccine or you have to comply with the testing option. The testing option is quite onerous, and the whole point of it is to force people to get vaccinated. I mean, employees have to pay for it. They have to get it weekly. They can only do it under certain conditions. It's a real burden on employees, but it does give you the option of, you don't want to mandate the vaccine, you do have an option that you don't have to terminate these employees. You can require them to test, but the testing option, I would say, is employees are going to find it burdensome to have to go get tested every week and report that and pay for it.
Yeah, I'll jump in behind Brett. For those clients with whom we've spoken who are both contractors and over 100, they are more often than not mandating pursuant to the federal government mandate because it's easier, cheaper, more efficient, just from an operational standpoint.
Great. Awesome. We're going to keep it moving. Are you seeing trends among employees mandate vaccines, wait and see, or refusing to mandate? So are you seeing mandate vaccines, wait and see, refusing to mandate?
Andy, you want to? I think you just touched on that. You want to take that one?
Sure. My experience mostly has been with the government contractors who are required to do it. The litigation has stopped that, though most are continuing to plan and anticipate that some kind of mandate eventually will apply. If you had asked me a month ago whether litigation regarding the contractor mandate would be successful, I probably would have said no, because it has been so unsuccessful in the past. I think I'm changing my thinking. The Georgia decision I thought was very well done, and the focus there is that while the president has this authority under the procurement statute, this really isn't procurement related. This is a national health policy, and that's beyond that statutory ability. So it's all over the place, depending on industry, depending on size of company. But most of the folks that I've talked to, they are keeping an eye on it, particularly government contractors, presuming that there will be some sort of mandate.
Yeah, the only thing I'll add to that is, unlike Andy, I'm not talking to government contractors. Unlike Jim, I'm not talking to tons of employers about labor and employment compliance. I'm talking with folks who are more interested in challenging the mandate. And so from my perspective, what I've heard is the companies that are strongly opposed to the mandate are mainly in the South, or mainly in industries where you would expect the workforce to be more conservative, more Republican, opposed to vaccines. And so those types of employers are being more responsive to their workforce and avoiding vaccine mandates because they don't want people to walk off the job. and considering litigation or just taking a wait and see approach.
Awesome. Thank you. Looks like we're just about out of time, so we'll have to conclude our Q&A, but I want to thank everyone for submitting such great questions. And Caitlin, I'm going to send it back to you.
Thanks, Rhonda. And thank you to all of the Allegheny Conference regional investors who were able to participate in today's special topic briefing. We really do hope that you find these programs useful. And a big thank you to Jones Day Pittsburgh and partners Jim Urban, Andy Jackson, and Brett Shoemate for presenting and answering questions today. We really appreciate it. And we'd also like to again thank our sponsors, Giant Eagle, PNC, Gateway Health Plan, Highmark Blue Cross Blue Shield, Peoples and Essential Utilities Company, PPG, and UPMC Health Plan for their support, which allows us to offer programming such as today's. This concludes our special topic briefing. I hope you all have a good rest of your afternoon, a good weekend, a good holiday season, and a good end to 2021. Thanks. Bye.